On the jury instructions, there was one page where the heading was down here instead of on the top of the next page. So I just switched it out with another page. But otherwise, they were good to go. Okay, with regard to the seating arrangements, we are making an effort to get everyone in here that wants to observe in here that can. So if we ask you to scoot over, I'm going to ask you to do that. If the deputy, is trying to fit someone in, if you'll make accommodations, I would appreciate it. I really am trying to make an effort that if somebody wants to observe the trial, that they get to. I've made the accommodations for both families, and so I think we're set. We haven't had any issues with regard to that, but there's been some other people today that's tried to come in, and so we are making arrangements, so you may have to sit close so that people can come in and observe. Might not be able to make arrangements for everyone, but we had a few more seats, and so I wanted to try to get a few more people in. Okay, anything that we need to address before we bring the jury into the court? Okay, we're ready to bring them in. Mr. Thompson in the third row. He could probably sit in the first row. That'll save a seat back there.
Jury's present. All rise.
Please be seated. Okay, closing argument on behalf of the defense.
Good morning. On behalf of defense, we appreciate your attentiveness during the course of this trial. Hill family, Bradley family. Shortly, the judge will instruct you on the law that you're to follow in this case. And it's within these instructions that you'll find the law. It doesn't come from Mr. Brown. It doesn't come from me. It's in here. If I say something that doesn't match up with these instructions, call me on it. I expect you to do the same for anything that the state misinstructed you on. Call them on it. This will be our opportunity, our own opportunity, to speak with you. And at the conclusion of this case, when you're back in the jury room, be thinking, actually be thinking about it during the state's final argument. Be thinking about that Mr. Lanning's not going to have a chance to respond. What would he say to that? And when you're in the jury room, stand in my shoes. Say, no, wait a minute. This happened. That happened. One of the instructions for what we'll read is the weighing the evidence instruction. And it tells you how to consider the evidence that you've heard during the course of the trial. It gives you a non-exclusive list of things to consider in debating the evidence. The witness has the opportunity to see and know the things about which the witness is testifying. The witness have an accurate memory. Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case was to be decided? Did the witness at other times make inconsistent statements in their courtroom testimony? Has the witness been convicted of certain crimes? There's other matters. It's a non-exclusive list. But the instruction that the witness have a case of interest, now the case is to be decided. This central theme of this entire case. Certainly Brandon Bradley has an interest. It's his life. Henry Kirshner certainly have an interest. It's something that hangs over this case more than any I've ever done. Is the interest of law enforcement, the Lord County Sheriff's Department, and all that it's lit. This was a long-time law enforcement vet who died, and tragically, sensitive. Law enforcement is family. When Barbara Pill died, that was one of theirs. They enforced the laws here in this county, as well as other local city agencies. Those at this table prosecute those offenders, and they work hand in hand throughout the course of this trial and any other case involving the sheriff's department. And that interest hangs over this case in some negative ways. This case was investigated by longtime colleagues of Barbara Pill. And some questions that I would pose. Did the Sheriff's Department interest in how this case is to be decided? Did it affect the way records were gathered in this case? For instance, phone records that were presented, a sliver of the actual records. scrutinized for their accuracy by the Sheriff's Department? Or were the records they wanted before you presented, and then records that maybe weren't so accurate, not? Is there an interest in not producing a Metro PCS worker that could testify to the accuracy of those records, but instead a Sheriff's Department employee comes in and tells you they're accurate? These are accurate. No, these others kind of debatable. Oh yeah, they're not evidence. They're not before to consider. Did the Sheriff's Department's interest affect the decision not to get a search warrant for his blood or urine, get a court order? Detective Reynolds, he's out there at the Janewood address. His testimony, when they find the phone, getting it together to get that search warrant for those phone records. Wistoff Labs, go right down the street, get the court order, we got him in custody, get your blood. Mr. Bradley, you give us your pupil swabs. You didn't even ask for his blood. About the decision not to have a drug recognition expert involved right up front. They had plenty of evidence of an indication that these people were trashed. Witnesses from the hotel looked high at me, just vacant stare. Yeah, these people are carrying furniture out of the hotel in broad daylight at checkout time. Plenty of indication. There's pill bottles all over that vehicle. About the failure to have field sobriety tests. Did their interests affect their decisions in the testimony of the deputies that questioned Brandon Bradley? They never even questioned him about drugs. Did they turn a blind eye? Did they purposely avoid going into that? Did their interest affect their scrutiny of their witnesses? Did it affect how they dealt with Jeffrey Villegas? Villegas has got a bottle of pills found in the vehicle they're in. He's on probation. About reasonable inferences from the evidence. How did the deputies first approach Mr. Villegas? Did they go down to the hospital and say, "Hey, pal, the pills are in these fleeing felons' vehicles, selling and buying? You can't do that on probation. You know, you go to prison here." By the way, Mr. Villegas, these phone records kind of indicate maybe you were on the phone. You heard something. You might be able to help yourself. Did their interest affect how they dealt with Andrea Kirch? Brown, read you heard about that principle theory. Each person is liable for all the acts of the other in a criminal enterprise. Kirchner, she's going to walk out of prison in 8 or 10 years. Still a very young woman. Treated the same? Did their discretion, did their interest include giving the woman who possibly had years and years of reasons to lie on the witness stand? Did their interest affect letting Andrea Kirchner cutting a deal with her from the beginning? Or did they just want Brandon Travis that bad? He had to pay. Did it affect the officer's testimony? Officer after officer. No, they looked fine. No problem. Answered questions clearly. Had no problem walking and talking. We know from other witnesses that once he was taken into custody, he's in the police department interview room and he's passed out sleeping for 7 hours. Officers come in, tried to wake him up, weren't able to wake him up. And eventually, hours and hours later, bring him in, sit him up, prop him down in a chair. Did their decision, their evidence, in fact, their decision to bring in Amanda Osborne a few days after a C-section to put her on for the purpose of establishing that he had a gun, nervous around cops, knew he had a warrants. Or was their real purpose, and what you can't consider, what the court instructed you, you can't consider. Her prior statement as being true. Anything about holding Ford out in the street, you've been instructed not to consider it. But during his closing, it's exactly what he wants you to do. The only reason you can consider that statement is to cast doubt on her other testimony. But that self-interest in vengeance changed. They want you to use it against him. Use her statement, her prior statement that she repudiates, has repudiated, was forced to come in here to say, why did she repudiate it? Because she said it has no credibility. She was drugged out when questioned over a period of many hours by about, I think she said, half a dozen different agents, maybe 9, over different offenses, facing charges of her own. They want to use that. They want you to use it Did their interest affect the decision to charge him with premeditated first-degree murder, robbery, felony murder, instead of what this case actually is? This case is actually, it's not a whodunit. This case is a lesser degree homicide. Premeditated murder instruction said three elements. Orville is dead. Death was caused by the criminal act of Brandon Lee Bradley. Or was it premeditated killing of Orville? The act includes a series of related actions from and performed pursuant to a single design or purpose. Killing after consciously deciding to do so has to be present in the mind at the time. Period. It has to be long enough to allow for reflection by the defendant, and it has to be formed before the killing. Now, the question of premeditation is a question of fact to be determined by you from the evidence. Mr. Brown point on into the voluntary intoxication instruction. Because you can't consider voluntary intoxication as a defense. That does not take out the requirement that they prove a premeditated intent to kill. And you have to consider the question of premeditation is a question of fact to be determined by you from the evidence. Now, there's a tension between those two instructions. Because you do have to consider all the evidence. And this is the law. These are the instructions. If the question of premeditation is a question of fact to be determined by you from the evidence that weren't the law, it would not be in these instructions, and you must follow that. So you have to consider evidence. Evidence is that this was a drug fuel. All right. Again. What has the state presented in this case towards premeditation? Start with their witness. Start with my favorite, Mr. Diego. His stretch of felony convictions dating from the late 80s over in Hillsborough County, all the way into the late 2000 or 2009, his sales of cocaine, his robbery, his aggravated assault, in between. Got various crimes of dishonesty and false statement. He's a long time, the mid-90s, on pain medications, psychiatric medications. depending on what day you ask. You heard a siren there. Depending on what day you ask. You knew the defendant in his voice. Mr. Dieguez claims that when, during this phone call, he heard, and this applies to Andrea Kirchner as well, she got my tag. Well, that's not true. Tag didn't come back. Car hadn't been registered. They were still looking for trying to find out who the actual registered owner was. Later that day, interviewing Mr. Bradley. We know Mr. Dieguez is friends of the Kirchner, of Andrea Kirchner and her sister, who, during Ms. Kirchner's testimony, her sister's also a pillhead. She likes Roxy's. Not Ms. Kirchner's cup of tea, but her sister likes the Roxy's. And Mr. Dieguez tells you he and Andrea are friends, or Andrea as well as the sister are friends. And yeah, he's calling her at 6:30 in the morning. Maybe about 1 to 2. Different his description of who called who, when, why. But Mr. Lanning, I'll never forget that phone. Why don't you remember your statement to the police, Mr. Dieguez? Because I've been beaten and stabbed and robbed. But I'll never forget that phone call. Mr. Dieguez, truth is a river. Whatever part of the river you toss, part of the truth you'll get. He's a liar. He's a liar. And they do. They do. Did Jeffrey Dieguez get with Andrea's sister that afternoon? Go ahead and work this all up. Phone records weren't obtained until shortly before sometime before his interview, 5 weeks later, after the death. Did Andrea Kirchner get with Jeff Dieguez? Did Andrea Kirchner's lawyer get with Jeff Dieguez? Andrea Kirchner, their other premeditation witness. She testified that Mr. Bradley saw the deputy's car, he was paranoid, made statements on going back to the road, and that she had seen his tag. And it dovetails so well with Jeffrey Dieguez. But she admitted in her testimony that she had lied repeatedly to the agents. Had lied about everything from the beginning, pointing the finger at a third person. She admitted and still says she's been on a drug binge for weeks. That memory's still fuzzy. Can't tell what's her lawyers she saw. And that's the same thing, that she was crying and begging. Does that match up? Does that jive in any way with the woman who conceded that during her interview with the police, she made statements to them like, Deputy, she came over there rude as fuck. To them like, if I shot the bitch, I'm going to tell you. She came over there rude as fuck. If I shot the bitch, I'm going to tell you. I don't like that conduct. What they about Andrea Kirchner's phone record? Those records in the 32-minute call, it indicates call wait. Doesn't it? All that other calls, it will indicate call answer. Doesn't even indicate the call answer. I guess a Metro PCS person might be able to explain that. But you get that. There are other premeditation lists. Amanda Osborne. It's not a premeditation. I want you to consider her testimony for something that you are obliged or you're obligated on. You can consider her testimony had a gun, nervous around police, had warrants. The other statement can only consider it to impeach those others. It's a negative. Address a couple of the other instructions. The felony murder instruction. If it's not premeditation, you know, I want you to go to that felony. It's a felony. Prove the first-degree felony murder is stated to prove the following three elements beyond a reasonable doubt. Barbara Pill is dead. The death occurred as a consequence of, while Brandon Lee Bradley was escaping from the immediate scene of a robbery. 3, Brandon Lee Bradley was the person who actually killed Barbara Pill. I would submit that what is proven in this case is mere theft of property by Andrea Kirchner. It was reported as a theft, reported as a robbery. It's been overcharged again. The only witness we've heard from that ever even put Brandon Bradley in possession of the property was Mr. Montesano. Couldn't remember what property. Said he saw it. Well, Mr. Bradley told him at some point, picked up a piece of property, tells Andrea, "You can't take this. What is it?" Bullshit. Didn't take the nightstand. And then Mr. Montesano said he went back to what he was doing, he closed his curtains and took a shower. So Mr. Montesano may very well have seen Mr. Bradley having that conversation with Andrea Kirchner. We know from Mr. Jordan, Bradley, he's in his car, it was just a vacant stare. Not that he knew he was there, or not that he acknowledged him in any way. By all indications, Andrea Kirchner is carrying property, but then she's also going down the stairs, raising hell, and yelling and screaming. There's no indication that Brandon Bradley had a conscious intent to steal property from that location. Certainly didn't have an interest in it. Andrea Kirchner, it's in evidence, the registration card from that hotel, her name, her driver's license number, parents' address. The second reason this is not a felony murder, no proof that Brandon Bradley was escaping from the immediate scene of a robbery. Mr. Brown, several times when he told that instruction, he left out immediate scene of robbery. Immediate scene of robbery is the Econo Lodge Inn. If it's a robbery, it's a theft. But immediate scene is there. It's not 3.5 miles away.
Check, approach.
Yes, you may.